A very good morning to all the viewers. Myself, Dr. Rajesh Kumar Singh, Associate Professor at Parul Institute of Law, Parul University. I warm welcome the MNS speaker, Mansi Kumar from Jindal Law College from Haryana. So let us, and the topic of this webinar is on the drafting of alternate dispute resolution clauses in commercial contracts. So this is a very interesting to, Madam, first of all, I will just introduce about our university. We have, Madam, total 5 years program, BLLB, BCom LLB and BBLLB. And we have, Madam, around 500 students at our university. 180 students are pursuing the master degree programs, and 26 students are doing the PhD, enrolled in the PhD programs, ma'am. And this is the one of the toppest and renowned university at Gujarat, ma'am. And this is the one of the leading university at Gujarat. Now pertaining to, now I will just introduce about our speaker. So let me introduce Professor Mansi Kumar, has a Juris Doctor from Lewis and Clark Law School in the United States, where she is also served as internet editor of the Lewis and Clark Law Review. She graduated cum laude and was inducted into the Cornelius or Honors Society, an honor given to select the graduates by the professor of the law school. Ms. Kumar legal experience is varied in the term of the both practice and geography. She was an associate professor, well-known law firms in India and the United States, where she has been involved in the litigation and the international arbitration. She regularly appears in the court of the US, and she has worked in the diverse set of the practices area, including the oil and gas, government procurement, insurance, maritime, construction, and general commercial dispute resolution. She is admitted to the bar of the state of Oregon and the US District Court for the District of Oregon. She teaches a popular seminar on the commercial contract of the drafting. So as per a wide experience on the drafting, I warm welcome Mansi Kumar madam. Now I will introduce about the Ruchi Tiwari madam. She is Associate Professor at Parul Institute of Law, Parul University. I just request Ruchi madam to warm welcome Mansi Kumar ma'am. Ruchi madam.
Good morning, Manasi ma'am. I have a privilege to welcome you on behalf of our Dean sir. As sir already mentioned that sir is not well today, sir is not doing well today. That's why I am being privileged to welcome you. I am Dr. Ruchi Tiwari, an associate professor who basically deals with commercial contracts and teaches contracts since many years. So was listening to you and looking forward to the webinar, and obviously I'll ask sir also to help us with the drafting of commercial contracts in future too. And ma'am, at Parul, we believe this is where you begin. The future is today. So bridging the gap of academicians and the teachers and the professional lawyers, and making our students to be to develop in such a sort that they can even practice in this pandemic situations. Getting an internships for the students is also a task. So this is going to help us for that also. So ma'am, I welcome you on behalf of Parul University, Faculty of Law. Thank you so much, ma'am, for sparing a time for us. Thank you.
Thank you, Dr. Tiwari. Thank you, Dr. Singh. This was a very, very kind introduction. I'm very pleased to be here with Parul University, and I want to commend you on having this very active online webinar series you have for your students. I believe that this is an absolute exercise of the practice of law and injecting that sort of living the law into the studies for students. So I hope I am able to provide a little sliver of practical advice in their larger pursuits in contracts. So should I go ahead and share my screen?
Yes, ma'am. Yes, ma'am. You can start, ma'am, session.
Thank you. So I hope you can see my screen. Today I want to speak specifically about drafting alternate dispute resolution clauses in commercial contracts. In India, there is a new, well, it's not new. However, let's say that, at least in the past 10 years, there's been a resurgence of interest in arbitration. And there are a lot of young students and law professionals who are interested in pursuing arbitration, either from a practitioner's perspective of being a dispute resolution attorney, or they want to go ahead and also be an arbitrator in the future at some point, or they're just interested to see how this is developing. Now, with that, I always like to remind my students that while you all have a course on alternate dispute resolution and you study the Arbitration and Conciliation Act, as a contracts professor, my interest in arbitration is really as it is a creature of contract. So that overlay between ADR and contract is where my interest lies. And I find that a lot of the issues that one sees students grappling with and struggling with, we can, as practitioners, sidestep them by taking certain drafting choices knowingly. And with that, I want to introduce you to two principles of contract drafting, which I hope is going to serve as a couple of pillars to guide you through this topic as we proceed. The first task for you is to ascertain the party's intention. And the second task for you, the more difficult, I would suggest, task for you, is to make sure that you are clearly communicating the party's intention. And these are the same two principles that also apply to drafting arbitration contracts. There is an immense amount of flexibility and freedom for practitioners to create a bespoke arbitration clause for their parties to meet their precise needs. So no one arbitration agreement should ever be copied and pasted into a contract. I do believe in using templates. I always tell my students, please use templates. Do not reinvent the wheel. The internet is a fantastic marketplace of ideas for drafters. But I do suggest that whenever you take your template, make it fit the particular transaction you are working on. And so with that, we should discuss these ADR clauses, briefly talk about arbitration, more in depth we'll talk about arbitration, and briefly at the end I'll talk about mediation and negotiation as well. But let's talk a little bit about also the statutory framework and see where your freedom as drafters comes in, and then what kind of choices you can make and why people make the choices they do make. So first of all, of course, you are well aware, I'm sure by now, of the Arbitration and Conciliation Act, and Section 7 says that the arbitration agreement has to be in writing. So this can also be by an exchange of letters, emails, or at the time of pleadings. We are not concerned with that. We are concerned with the drafter at the time that the parties are entering into a transaction. They'll set down arbitration as their choice of dispute resolution. So if it has to be in writing, this is where we come in. We have to draft it appropriately. And of course, you know that in India, there is a distinction drawn in the Arbitration and Conciliation Act between Part 1 and Part 2. Part 1 applies to domestic arbitrations and generally considers how the arbitration should be conducted, when one can appeal. And Part 2 deals with foreign-seated arbitrations, which generally deals with the enforcement of an arbitral award. So these are just broad brushstrokes. As I lead you through today's presentation, though, I'm going to follow a few topics, and I'll just list them for you now. We'll discuss each one in turn. So the first question for everybody has to be, have the parties been properly identified? If you are having an arbitration agreement, the agreement has to be between certain parties. You have to make sure there's a clear identification of the parties. You have to ensure that there is a clear reference to arbitration. What disputes are being submitted to arbitration? What is the law of the arbitration? This is a very tricky area which you, I'm sure, spend weeks discussing in class. And I want to give you just a very quick overview and tell you as a drafter what is the nutshell of what you need out of it. How will the tribunal be appointed? Do you want to consider stating that there should be certain arbitrator qualifications? How many arbitrators? Language of arbitration. What will be the language of arbitration? What about the costs of arbitration? Who will pay? Is it final and binding? And finally, if we have time and I'm not running over, I would love to talk to you about multi-tier dispute. Sorry, I will talk to you about multi-tier dispute resolution clauses. At the end, if we're not running out of time, I would love to talk to you about multiple contracts. And there's a very new and exciting area thrown up by the Supreme Court in the Plural Controls case, which for drafters is a gray area. And I always make certain recommendations to students about how to try to sidestep that jurisprudence in their contracts to see if that works. But we will see if time permits, we will do that. Okay. So the first one is, have the parties been properly identified? And here you have to identify the company or the person clearly. I would like to suggest to you that most of these arbitration clauses you will find inside a main substantive agreement that lays out the main transaction between the parties. And so that will already lay out who the parties are, so you don't have to really worry about it at the arbitration clause level. If, on the other hand, you are drafting a separate arbitration agreement with reference to another contract and another dispute, I always suggest to people, please do not follow the traditional approach of saying, Ms. Mansi Kumar, daughter of Shri Yogendra Kumar, aged such and such. That is not a precise definition. There can be many Mansi Kumars who are daughters of Yogendra Kumars, who are aged a certain age, who live at a certain place. It's not precise. What is precise is the Aadhaar number. That's unique. There's nobody else who has that Aadhaar number. Your PAN card number. And for companies, use the company identification number. When you're simply trying to lay out the identification of the party, it is best practice to take unique identification numbers and lay them out. Second, is there a clear reference to arbitration? Now, this is a little tricky because consider the drafting that I have put up for you. The example says arbitration, if any, by ICC rules in London. And this was a case in the UK which upheld the clause and said that this was a proper reference to arbitration, but there was an embittered fight over it, right? And as drafters, you want to make sure that there's no uncertainty, so there's no fight. Now, what's the ambiguity here? Well, it says arbitration, if any. So there are two possible interpretations here. One is that if there is any dispute, it has to be resolved by arbitration. There's another possible and reasonable interpretation, which would be, if there is any dispute, and if the parties agree to arbitration, then the arbitration will be by ICC rules and in London. So that kind of language is very imprecise and you should avoid that. I generally tell students, please just say the parties shall arbitrate. Just those 3 words or 4 words, the parties shall arbitrate. Right? You lay it out as a covenant that you have to arbitrate, the parties are promising to arbitrate. And you leave out any ambiguity that can come up with more shorthand drafting like this. So please do make sure that that reference to arbitration, that the parties are actually submitting to arbitration, is clear, just by saying parties shall arbitrate. And then the question arises, well, what disputes are the parties agreeing to arbitrate? And this can be a little tricky. So there's quite a bit of language you find in these arbitration clauses. You can have language that says arising out of or arising under this agreement, disputes arising under this agreement. You can have disputes related to this agreement. And within that, we have to also discuss what to do with non-contractual claims, like torts. So let's talk about what disputes. I've given you on your screen at the bottom, there's a clause, and it says the parties shall arbitrate all disputes arising out of this agreement. Or you can say arising under this agreement, even. Now the dispute, let's say this is a clause, and a dispute starts between parties, and one party actually alleges that there was a mutual mistake of fact at the time of entering into the contract, which even the arbitration agreement. The question can reasonably be raised. A mutual mistake of fact is a vitiating factor to any contract being formed. In other words, what the party is complaining about predates the contract. It predates the contract. So can it be said to be arising under this agreement or arising out of this agreement? These kind of battles can start off. So you can find language that comes in that says arising out of and related to this agreement. That is generally understood and agreed to be broader language that covers the validity, the formation of the arbitration agreement itself. But what about non-contractual claims that sound in tort? Many times a contractual relationship can also, if there's a dispute, can also raise claims that could be deemed to properly sound in tort, but they're not actually a contractual claim per se. And these arguments do exist. There's an interesting Guwahati High Court case on this as well. I'd be happy to share some case names and citations later if there are questions on this. Well, if it's arising out of and related to this agreement, does a tort fall into that? Arguably, yes. Because a tortious claim is related to the agreement. But many times, just to get rid of any doubt, recall, as drafters, we are concerned with certainty. So to ensure that there's certainty, you will find this language tacked on at the end that says disputes arising out of and related to this agreement, including torts. And there you have it. That's the broadest sweep of what disputes can fall under arbitration that a person can legitimately get away with. Because of course there are some legally non-arbitrable claims, certain types of fraud, etc. But of what is arbitrable, by using this broad language, you're bringing everything within its ambit that can easily be referred to an arbitral tribunal. So keep that spectrum in mind, that very narrow, that if there's a breach under the agreement, then it arises under. But if we want to also talk about validity and formation, we may want to also say it's related to. And then just because the word agreement is used to prevent somebody from saying that that implies only contractual claims can be raised in an arbitral tribunal, you include the language of including torts. And this should pretty safely get rid of any any challenges as to what disputes are being referred to an arbitration tribunal. And now we come to the law of the arbitration. This is the student's nightmare. This is the litigator's nightmare. I feel comfortable saying this is everybody's nightmare. there are books and chapters spawned by this topic. But the good news for a drafter is that you don't have to get too much into the nitty-gritty about it. Instead, most of the cases we see coming up right now, we could have properly been avoided through solid drafting. And a lot of the problems arise in this regard. I would say almost 90% of the problems are really arising out of very poor drafting, negligent drafting, unthinking use of templates. So let's talk about a quick overview. So what's the law of arbitration? There are a few things that we have to consider. One is what law applies to the arbitration agreement and the procedure. The second is what courts have supervisory jurisdiction. If you're angry with a certain tribunal, if you are looking for an interim order, what court do you go to? Or if you want to appeal your award, what court do you go to? What courts have supervisory jurisdiction? And these are usually decided by the seat. The seat of arbitration, which we'll just get into, is usually used as shorthand. So I'm just alerting you to that. There's also the question of, within the ambit of the law, how will the arbitration itself be conducted? As you are no doubt aware, arbitration itself is a more informal process than the courts. The rules of civil procedure and evidence do not hold sway as it would in court. But over the latter half of the 20th century, a lot of international organizations started coming up, institutions started coming up, because parties were happy to not be subjected to the rigors of court, but they also did not want it to be completely silent. They wanted some framework with regard to hearings and timelines and a little bit, you know, they said some basics should be there. So these institutions, you have the ICC, you have the London International Arbitration, they're all over. They came up, they've got a good business going. Now, the interesting thing about them is that each one of them has set up their rules. You can look at the ICC rules of arbitration, LCIA rules of arbitration. In the US, there's the AAA, American Arbitration Association rules of arbitration, and you can incorporate them. You can either go through the institution itself, you can, you know, they will actually then help you sort of monitor how the arbitration goes through, or you can just apply their rules. You can just take their rules and say, hey, we like those rules, so let's just take those rules to provide the framework we need. So that's where people talk about, do you want to have an ad hoc arbitration or an institutional arbitration? I suggest, even if you're having ad hoc, meaning you're not going through an institution, consider if you would like to have ICC rules nonetheless apply to provide some basic framework to your arbitration. Now, what's the seat? The seat, I like to tell my students, is an anchor. Your international, any arbitration, your arbitration cannot float in the ether. It has to be rooted somewhere, because it's going to tell you who is the court you get to go to. So when it's rooted, when your arbitration weighs anchor down in a place, that's when courts say, okay, so where the anchor has fallen, that is the law that governs the arbitration. That is the law of arbitration, and those are the courts that have supervisory jurisdiction. And in India, the tricky thing in international commercial arbitration is not many parties want to be subjected to Indian arbitration. The reasons are manifold. Indian courts take a long time. We have blocked dockets. We also have jurisprudence that is somewhat problematic. Things are improving by far, but it's going to take time. And of course, you can see also the eagerness with which the Parliament is making the amendments that they're making to the Arbitration and Conciliation Act. And some of them seem to go back and forth on certain principles, whether to include, whether to exclude. So we're still developing the maturity of an arbitration hub. So before we can become an arbitration hub, we have to go through this process. So in the interim, international arbitrations tend to be located somewhere else. They tend to prefer the seat to be somewhere else. And that's where you find something, even in contracts that the government of India gets into. Instead of Indian law applying, instead you'll find the seat of arbitration is London. So what this tells us is the English Arbitration and Conciliation Act applies. Their act is also 1996, just as ours. And that the London courts have supervisory jurisdiction. Now, I want to point that out to you. Please note that the seat is usually placed in a city. And the reason it's a city and not a country is because those courts are given exclusive jurisdiction. So it actually kind of serves as an exclusive jurisdiction clause as well for purposes of the arbitration, in relation to the arbitration. If you said the seat of arbitration is England, then one could say, okay, which one of the courts in England can we go to? We can go to any one of them. No, you should, they say that the city to make sure that that exclusivity is maintained. In India, Balco, the decision of Bharat Aluminium Co. and Kaiser Aluminium Technical Services in 2012 really clarified that in India, if you're going to have the seat be a domestic city, then Part 1 of the Arbitration and Conciliation Act applies. If you're going to have it be a foreign city, though, Part 2 will apply. And this was significant because before Balco, there were a lot of, the courts were really using appeals against arbitral awards to reopen and relitigate. Even if the arbitration was happening in London, the Indian courts were hearing appeals against it. So that created a lot of uncertainty and a lot of distrust towards Indian courts and the way they handled arbitration. So the Supreme Court, again, in the last 10 years only, finally said, no, we should not do this. This isn't proper practice. And they interpreted the ACA correctly, I believe, by saying that, look, if the seat is domestic, then we can say Part 1 applies. If the seat is foreign, then we say Part 2 applies. This did lead to one problematic question, though, which was, if you're in London and you are representing the, British party, say, and the opposing party is the Indian party, you might be interested in coming to India and having the court grant an injunction against the Indian party from liquidating their assets, so that after the arbitration is done, you come to enforce the award and whoops, there's no money. There's nothing to be found, right? Then the award is just paper. It's just ink on a paper. It hasn't actually given your client a remedy. So they said, well, we should be able to appear in India and ask Indian courts for some types of help. For example, for interim relief when it comes to protecting assets, and for help in maybe securing witnesses and documents if there's evidence in India. So in 2015, our legislature came up with an amending act, and they amended Section 2.2 of the Arbitration and Conciliation Act. And here they said that provided that, subject to an agreement to the contrary, the provisions of Section 9, which deal with interim relief, 27 I believe that is about evidence gathering. And 37.1a and 37.3 shall also apply to international commercial arbitration, the part 2, even if the place of arbitration is outside India and an arbitral award is made or to be made in such place is enforceable and recognizable under the provisions of part 2 of this act. Now, this was great, but for the contract drafter, something has come up here. Something is interesting. It says, provided that subject to an agreement to the contrary. Now, this is a strange little clause thrown in here. We cannot understand why the legislature did this, but arguably one can exclude Indian courts having any say in the matter. But what people are suggesting is that if you want to get around this, if you want to get around any arguments in court that, you know, is an express agreement needed or is implied okay, because the Law Commission had actually said subject to an express agreement to the contrary. So people have started making arguments, apparently, that if you have chosen the seat in London, then impliedly you have an agreement that the provisions of 92737 don't apply. And that's clearly contrary to the intention of the legislature. So for drafters, and I must thank Ms. Sonali Mathur from AZB Partners, who gave a wonderful presentation, and I asked her this question, and she told me that actually they've started dealing with this in their drafting. They've started putting in their arbitration contracts. The parties acknowledge that sections 9, 27, 37.1a and 37.3 apply to this arbitration. So even if you choose London, please consider putting in the language, the parties acknowledge that Indian Arbitration and Conciliation Act, these sections apply. That way you can always come to Indian courts to seek their help in getting evidence, in summoning witnesses who are not coming to the arbitration or not presenting themselves in front of the arbitral tribunal. Sometimes you really need the muscle power of the court, the police power of the state to help you make sure that the arbitration is proceeding smoothly. So yes, so that language is up there that I have presented. This was, I thought, an excellent drafting innovation that we see today, that you should use. It is smart practice, and that way you never have to worry about arguments about implied agreement, express agreement. Poof, out of your mind. You don't have to worry about it. So drafting can really help you free up a lot of mental space not to worry about things. Now, the seat is not the same as venue. And I sometimes somewhat facetiously tell my students, if the seat is the anchor, think of the venue as the menu card. The most it's doing is telling you how expensive your plane ticket is going to be and what you're going to eat for your meals. The venue is where the arbitration is going to be held. So, for example, I remember when I was working with Fox Mandal, I came to Gujarat, I came to Ahmedabad for an arbitration hearing. But the arbitration hearings were moving from city to city, depending on trying to make it convenient for parties and depending on where the evidence was. If we needed certain witnesses from Ahmedabad, we would be in Ahmedabad. If we needed certain documents in Delhi, we would just be in Delhi. So that kind of the venue can shift and change for the convenience of the parties, the convenience of the arbitrators, the convenience of evidence gathering. But it has no say on the law, no say whatsoever. So it's simply a matter of convenience, but we have a bit of a problem because, again, poor drafting. Consider this, arbitration proceedings will be held in New Delhi, okay? Now, are they talking about the seat or are they talking about the venue? Is New Delhi the seat now, or is New Delhi the venue? And the Supreme Court can't seem to make up its mind. So the Union of India versus Hardy Exploration, a 3-judge bench, says that such language is not the seat, that we're going to assume that such language actually just means the venue. And, unless we find some other indication in the contract, the parties actually intended this also to be the seat. But the presumption is it's just the venue. Less than a year later, BGS Soma case comes up, and another 3-judge bench. And this 3-judge bench says explicitly Hardy is wrong. This language means the seat. The presumption has to be that this is the seat, and you have to show me some other contrary language in the contract to say, no, the parties meant this to be the venue. And this is really interesting because in India, the BGS Soma case and many judgments, they talk about this Shashwa principle. I don't even know if I'm pronouncing it right. But it's the case of, it's a case from England, and it was from the Queen's Bench Commercial Division, which is a 3rd-tier court. So the UK has the Supreme Court, it has the Court of Appeals, and then it has the Queen's Bench. So it's a 3rd-tier court. And there the court was faced with the question of the venue of arbitration will be London. And the other party argued, no, it's going to be India. The seat is India. That's just the venue. And the judge there said that, look, London arbitration is, well, London arbitration. People do go to London to arbitrate. When people want to go to London, they're not just saying this will be convenient, but generally they like the legal framework, they like how the courts are functioning. And so in that case, because the venue was chosen to be London, the court said, and they had chosen, I believe, ICC rules. So the court said, they've also chosen these supranational rules. It seems to be that the parties really intended the venue to mean the seat. As I said, this is a 3rd-tier court in UK. As far as I'm aware, I don't think the Supreme Court has made anything out of it. Indian courts have made this into a principle. We have elevated this into a principle. And I, for one, don't understand it. I'm happy to be disagreed with. The principle, as they have taken out from Shashwa, is that any time a venue is mentioned, it's presumed to be the seat. I find that a little ironic, actually, because to be honest, one cannot help but suspect that because the choice was between London and pre-Balco Indian courts, perhaps the English judge was actually trying to save the parties' arbitration and keep them in an arbitration-friendly jurisdiction. And in the express language, they had limited it to London. But we have blown it up and made it into a general presumption. And so if you're a litigator, this is something to keep your eyes open for. We're going to see changes and how this matter finally settles, hopefully sometime soon. But if you're a drafter, you should never be reading these cases, because you should just simply be putting down the seat of arbitration is New Delhi. And unless the parties otherwise agree in writing, the venue of arbitration is New Delhi. So if you just use the language of seat and the language of venue just to show that you know the difference, you're fine. You are fine. So let the litigators get into the niceties of litigating poorly drafted contracts. You get into the habit of drafting a clear contract. And this, given current jurisprudence, this is absolutely clear and should lead to no problem. So I highly recommend that you mention the seat, knowing that it's the law of the arbitration and an exclusive jurisdiction clause that way. And then you mentioned the venue, knowing that, you know, okay, the parties can agree otherwise, that, hey, actually there's some good evidence to be had in another city. So we should actually all have our next hearing there. Moving on, how will the tribunal be appointed? There are two common choices here, 1 arbitrator and 3 arbitrators. The idea is obviously that you want to have an odd number so there's no gridlock. You have to decide with the 1 arbitrator, do you want to appoint them with mutual consent, or do you want somebody else to appoint them? How will they be appointed? With 3, again, mutual consent, or the very frequent formula is appoint 1 each, and your appointees will actually mutually agree upon a chairman. So that, or you can mutually agree upon a chairman. So that is usually the kind of framework you have. Why do people go for 1 versus 3? This is a practical point. 1 arbitrator is much cheaper. So if the value of the litigation or the dispute is not too much, I would say please just keep 1 arbitrator going. 3 arbitrators, however, many times it makes parties feel comfortable, especially if they go by appointing their arbitrator, and then, you know, the chairman is sort of the neutral, mutually appointed one. Many times parties feel comfortable. There's a sense of the arbitrator they appointed being favorably inclined towards them. And that is actually something that is a huge issue these days. People are discussing about arbitrator neutrality. So, hey, let's call a spade a spade. People hire if you're appointing an arbitrator, they like to believe that that is their arbitrator. So if it's a large matter and there's a lot of money involved, go for 3. Go for 3. It's always, I mean, you're trying to litigate for your client. How will the tribunal be appointed? There's another issue here, which is arbitrator eligibility. That's your section 12.5 of the ACA and the 7th schedule. So there's also a recent judgment by the Supreme Court that says that if you cannot have a unilateral appointment of a sole arbitrator, even if it's through an ineligible party. So what this means is that there are a lot of contracts that, for example, with the government, that would provide that if there's a dispute, then the head of this governmental department is going to appoint an arbitrator. And people were very upset with that because, you know, where's the fairness there? So now, at least, we believe that the Perkins-Eastman Architects decision makes it clear that even because you can't sit as your own arbitrator, the 7th schedule says you can't do that. They say you can't even appoint another arbitrator. So the unilateral appointment is off the table. So that is one good thing. So do not do that. Many of you may go on to work with the government. Change their contracts right away. Okay? Arbitrator qualifications. This is also really important and very interesting because there can be cases that are industry specific that require a certain type of expertise. So you can either spend a lot of time getting the arbitrator up to speed in a construction industry matter that involves looking at a lot of architectural and engineering designs, or you can get an arbitrator who's quite familiar with construction, with the construction industry, and should be able to follow along with the expert testimony, etc. So this can be a real cost-saving measure, and it can also make people feel more comfortable that they're getting a good adjudicator, somebody who has a sound foundation in the industry and so understands the implications of their arguments and should be giving the quote-unquote right decision. So this is not in every case. You don't have to be a specialist for every contract, but for certain industries, the maritime industry, oil and natural gas industry, sometimes insurance cases too, definitely construction industry. So some of these industries can require some expertise, but it doesn't have to be all of them. Language, is this important? I've just mentioned foreign parties here, but we should also talk about India. We are a diverse, multilingual country. And one of the questions is that what should be the language of arbitration? I think a lot of us in India default to English because it's the kind of neutral language. But if neither party is feeling particularly comfortable with English, and let's say they're from two different states, let's say Gujarat and Delhi, then is it going to be in Gujarati or is it going to be in Hindi? And that kind of comfortable with the hearing. If you have, for example, an Indian party and a Chinese party, okay, you are going to want to decide what should be the language of arbitration. So language is actually very important, and you should ensure that you should just default, you should put in the language of arbitration will be in English, right? It's that kind of neutral language. But if there's a difference, let's say both parties actually would like to have it conducted in Hindi, then mention it's going to be in Hindi. Or Gujarati, then mention it's going to be in Gujarati. You should make sure that that becomes clear. And finally, stating that it is final and binding. This is not necessarily important in countries like India, where the Act already says that it is final and binding. But it's very important practice to keep in mind because not every jurisdiction has this kind of an approach to arbitration. See, we like to sometimes, look at ourselves very critically and say we're not a very arbitration-friendly jurisdiction. We are not even as bad as some other places. We're actually working very hard to make ourselves a very, I don't like to use the word pro-arbitration because that sounds like arbitration, hooray, regardless of what the meat of the arguments are. No, I like to say that we are developing a coherent set of rules and framework to deal with arbitration so that there's certainty for anybody who's wondering how an Indian court would decide this. There is a certainty and there's this precedent, this robust precedent that's being set up. So we're in the process of doing that. There are many other jurisdictions that are well behind us. And a lot of your clients may be doing business in these jurisdictions because these are big markets, in this globalized world. So in that case, you should be in the habit of including the language that the arbitral award will be final and binding for what it's worth. Okay? Costs, you have to decide who will bear the costs. So you can have something that says the parties shall equally bear the costs of the arbitration, including the fees of the arbitral tribunal. Or you can split it up and say each party shall bear their own costs, except that they will split the fees of the arbitral tribunal. So you can split it up that way if you want. But you have to deal with that because arbitrations are costly. There are, as I said, there are flight tickets, there are train tickets, there's venues to be booked. So it is expensive. So you should definitely include that. And finally, multi-tier dispute resolution. This is, again, something that is very up in the air a little bit right now. But I want to show you what you can do. And then one area where, well, we have to wait for the Supreme Court to weigh in. Okay, so in some very, let's say, big transactions, financially or in terms of the value that is involved, complex transactions, there could be, multiple projects going on, and ongoing transactions. Sometimes you have parties who enter into a project with each other, and it's not just a sale agreement, but it's a continuing project like construction, or with oil and natural gas, the drilling. These are continuous kind of, the relationship is ongoing. People get very concerned about how do we deal with disputes when the relationship is ongoing. See, it's one thing for us lawyers to be like, fight, 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 fight. But these parties have to deal with each other. They still have the remainder of the contract, the remainder of the transaction to go through. They still want to try to salvage this commercial relationship so that it can be mutually beneficial. So they don't like the idea that we should at the same time be working together and at the same time be sitting in arbitration. So what they like to do is they like to set up a multi-tiered dispute resolution system. They say, first, we're going to go for negotiation. First, we're going to go for negotiation and try to see if we can negotiate this. If that doesn't work, we're going to pick mediation. So we'll get a mediator in. The mediator is a trained professional who tries to get everybody to a middle ground and to do so in a manner that doesn't ruffle too many feathers. You know, that's the hallmark of a good mediator. And then it's only if the dispute is so far gone, then we will go to arbitration. So this multi-tier dispute resolution is really in a way to salvage a relationship that is ongoing. That is, at least in my opinion, what makes sense, when it makes sense. So there are a few things that you have to consider. Number one is the appointment of the mediator. Is it going to be a binding mediation or a non-binding mediation? You can also consider that. You can also talk about negotiation. Does it have to be negotiation in good faith? Now, whether the requirement of good faith is enforceable in India vis-a-vis negotiation is not decided. We generally tend to look for some inspiration to English courts as well. And in England, negotiations in good faith are not worth the paper they're written on, though in recent years, there has been a slight shift. So in many contracts, you will still find the language of negotiation in good faith. Whether or not it's enforceable, there's also a sort of a psychological impact of it, of telling parties, you know, here are the reasonable expectations of the other. Come to the table with an honest intention to try to negotiate for a resolution. So I leave that with you again for your consideration. How will the process start? Both for mediation and negotiation, does a formal notice have to be sent, or will an email suffice? Should the email have a certain subject heading? All these things can actually be written out properly for you, okay? And how long does it have to go on till the process is deemed to have failed? Please mention that, because there will be people who will say that, oh, we're still negotiating, but actually what they're doing is they're keeping you hanging. They're keeping you hanging. So the contracts should say, and many do, that, okay, if we don't have a negotiated settlement within 30 days, then the negotiations will be deemed to have failed, unless there's a written agreement to the contrary. And the final question is whether you want to set them up as mandatory prerequisites or optional. So if a dispute arises and one person just goes and files for arbitration, can you say, no, first we negotiate? Generally, I suggest to people always set them up as mandatory prerequisites, because that is the way one is trying to manage the contractual relationship. So make sure they're mandatory prerequisites. But this is where at least the Delhi High Court and the Bombay High Court disagree with each other. And the Supreme Court hasn't said anything so far, as I know. The Delhi High Court says that they cannot be prerequisites at all. They can only be optional. I think this is a reading of Section 77 of the Arbitration and Conciliation Act. The Bombay High Court disagrees with that and says, no, there's nothing in the Act that actually says that they can't be mandatory prerequisites. And in fact, in commercial relationships, it is commonplace to have them be mandatory prerequisites, and that intention has to be given, effect. So please set them up as mandatory prerequisites. If you, but study your jurisdiction, okay? Because in Delhi, you will have difficulty with that, at least. All right, I actually think I've taken up the full time, so I won't go on to the multiple contracts. but I hope that is sufficient to
Yes,
orient
ma'am.
you.
It is a really fantastic session, and you're really please send this PPT to me on the mail because I want to share with my students. And it was
Okay.
a very fantastic PPT we made by you and explained with the very good judgments. Madam, we have certain questions on this topic. Madam, first question from my one of the student of LLM. So, she was asking that whether this seat arrangement which you have shown, that seat, so if suppose there is a dispute and one arbitrator we have appointed, okay, so seat is, let us suppose it is costly in London and it is agreement in London and India, correct? So where is the seat is to be, where is the jurisdiction will lie? Because sometimes the arbitrator are costly and sometimes
Yes.
because in Indian arbitrator are cheaper. So
Yes.
so in that case, where to where is the seat lie?
That is an excellent question. And in fact, that is something that we must recognize. Arbitration, we like to hear people talk about how arbitration is speedier and less expensive than courts. I disagree with that. International arbitration is very expensive. These institutions I spoke about are almost exorbitant in the fees they charge. And in India, I think that there is generally a very good practice of trying to put caps on arbitrator fees and charging more reasonable amounts. Now, the student's question is a very legitimate question, especially if you have a dispute already and there's nothing mentioned in the contract. Then it actually falls to the arbitrator to decide where the seat lies, reading the contract and trying to ascertain the party's intention. And as a drafter, as somebody who teaches contracts, that is a terrible result because it's uncertain. Now we have to go and battle this out. Now we have to go and fight this out. Instead, what I suggest to your student is at the time of drafting, your question should be, I prefer India. So I will say the seat of arbitration is Ahmedabad. I will say the seat of arbitration is a city in India and I will not make it London. And then you can negotiate with the other party to try to do that. The only caveat I have for that is that foreign parties are still very uncomfortable with Indian-based arbitration. So it all depends on the bargaining power you have in the commercial relationship. Sometimes the Indian party, if you're representing the Indian party, sometimes you're the powerful party. And if as the powerful party, you have comfort with India, make it Indian seat. Take a city in India, make that the seat. But if you do not have, or if you're the weaker party in the bargain, as you're negotiating this deal, and your party really just wants, I need this contract for my business. I need this contract. Then I think you will find that you will have to give way to the other party and having the seat be in London. That being said, if cost is your concern, certain cost-saving measures can be put into place. You can refuse to go through an institution. You can say it'll be ad hoc and just say that certain institutional rules will apply. And then you can put a cap on the arbitrator's fees. You can say that, in no event will the arbitrator fees be more than this amount. So you can try to, if cost is the concern, and it is actually a very valid concern, then one can try to set caps on the cost. Of course, one has to do their research to evaluate what is the caliber and quality that one will get for that cost. One has to know the arbitration circuit in the place that is being chosen. So that will require you to liaise with some colleagues you may have in London or other places, wherever the foreign seat is being based. But that is why always put the seat in your contract. Never be left with the question of where is the seat. You are the masters of this bargain. So you can actually put it in your contract and say the seat is New Delhi.
Yes, ma'am. Very well explained, ma'am. We have one question from one of the PhD student, Mr. Abhijit. He has asked that if suppose a company who has located a company in India, okay, means they have established a company in India. Now, you know, in India, the workmen of Indian workmen were working inside it. So if suppose there is a dispute between the workmen and the company, so can we appoint an arbitrator which is going to be settled outside and if suppose, let us suppose 20 workmen were taken out from the factory on COVID situation. So we can appoint an arbitrator in this scenario, or we can settle, we can hire an arbitrator to settle a dispute without going to any courts?
Yes, yes, you can. That is to the best of my knowledge. You should talk to somebody who is a labor law expert to just find out if there are any exceptions to that in labor law, that certain matters have to go to court. But to the best of my understanding, a lot of contracts, employment contracts, actually have an arbitration clause in them. My employment contract has an arbitration clause in it. So lots of contracts have arbitration clauses in them. And you can actually enforce that. If you don't have an arbitration clause, you can suggest to the workmen that you can now, if a dispute has arisen, that we can now go to arbitration and enter into an arbitration agreement. I would suggest, though, one of the common techniques that are used, at least from in the US, one of the common techniques that are used in these kind of labor scenarios is to use the multi-tiered dispute resolution. The first thing is to try to get negotiation. The second thing is to get a good mediator, because these workmen are crucial for the company's business. They are important. If they are unhappy on a mass level, it can really interrupt the productivity of the company. So this is a case where there's an ongoing relationship where the first fight should not be in an arbitration tribunal, in front of an arbitral tribunal. The first discussion should be like the Knights of the Round Table. I don't know if you guys are familiar with the King Arthur stories from England, but you know, you have a round table and everybody sits around it and tries to be equal and talk to each other. And the second should be getting a qualified mediator in to try to reach a resolution. And hopefully that will be enough and should work. But then, yes, you should be able to arbitrate. Again, with the caveat that you should talk to a labor lawyer because I haven't gone into the nitty-gritty of all the laws that apply in labor law in India. And there may be certain exceptions that are carved out. So you may wish to talk to them and figure out what those exceptions may be, if any.
Very well explained, ma'am. Madam, we have certain more questions from the student that I will put on your mail. So please kindly answer on that mail. I will circulate to the student.
I'd be happy to.
Yeah, ma'am. And madam, on the behalf of Parul Institute of Law, Parul City, we are very much thankful to you on this platform. You have elaborated in a very systematic way and in a very slow way. My students are sharing that it was very fantastic session by you, ma'am. So for this note, I am thanking to you and from the Parul Institute of Law, Parul City. And ma'am, we will also like to invite you when this pandemic will over to at Gujarat, at Vadodara. And whenever our pandemic will be over, we will invite you physically, madam, and at this university, ma'am. So thanks a lot, madam, for your kindness.
It would be my pleasure. I've had a really nice time talking to you, and I am very pleased that I have been able to provide something of use to students. I'd be happy to answer any questions of theirs, and I wish them nothing but the best of success as they practice.
Yes, ma'am. Thanks a lot, ma'am. Thanks a lot.
Thank you, Rajesh.
I'm also thankful to this PU webinar team who has given a very good live coverage. So I'm thank you to Mr. Jitin Kobani, sir. So now, sir, we are closing the session. So thanks a lot, madam. We are closing this session, ma'am. Thanks a lot, ma'am.
Thank you.
Thank you, ma'am.